Good morning, everyone. Gigi and I will spend this webcast going through and explaining what cybersecurity is, why it's important, and our view as to what all organisations should be doing to protect their businesses. And what we hope is that the registrants today find the information useful for their own organisations. So if I mention to you the companies Optus, Medibank, Telstra, and Woolworths, what do they all have in common? They are all significantly large enterprises which have become victims of growing cyber threats and data breaches where customers' personal information, for example, driver's license numbers, passport details, Medicare numbers, addresses, and other contact details, have been accessible without authorization. You may ask, how is it possible that such large organisations with an operating revenue of billions of dollars become victims of a cyber attack? Wouldn't they have layers and layers of cybersecurity solutions in place for circumstances such as these? Optus's recent misfortune has revealed the very importance of cybersecurity in the growing world of cyber technologies. Not only is Optus now incurring costs of over $140 million to cover breaches, but the reputational impacts have also caused a ripple effect within its customer base and, of course, loss of profits. If such cyber breaches can impact on big businesses, think how easy it might be for hackers to access smaller to medium-sized businesses like yours. We all have valuable data in our business that we want to protect. We are probably all as vulnerable when facing cyber criminals. Not only that, depending on our business, certain privacy laws apply to the information we hold, which imposes strict obligations in terms of reporting to government authorities and notifying the affected individuals when a data breach does occur. Even small businesses can no longer put their heads in the sand and hope for the best. Unfortunately, businesses need to prepare for the worst. So in this webinar, we will cover the following. Are cyber attacks only a big business problem? And what are some of the common types of cyber attacks? We will explain the notifiable data breach scheme and other obligations under the privacy law and how they relate to your business. What can you do? What must you do? What does the privacy law say? How can we as lawyers assist in the event of a cyber attack? And what are some of the actions or steps that you can take now to increase your company's cybersecurity? So, are cyber attacks only a big business problem? If we only look at news headlines, it is easy to think that cyber attacks and data breaches are only a big business problem. But reality and statistics show us that small to medium businesses are just as much under attack. According to a study conducted in 2023 by MasterCard, 309,000 small business leaders experienced cybersecurity issues and were under some form of a cyber attack. Of those impacted, 33% claimed they experienced financial loss as a result. The Australian Cybersecurity Centre, which is the Australian Government Agency for Cybersecurity, forms part of the Australian Signals Directorate. Now, that directorate protects Australia's national security from cyber threats. In November last year, that organisation released an annual report for the last financial year. This report revealed that the average cost of cyber crimes per report was up by 14%, with small to medium businesses accounting for 143,000 odd of those reports. The top cybercrime types for businesses were, as you would expect, email compromise, business email compromise and fraud, and online banking fraud. Now, for small businesses, the average losses as a result of cybercrime incidents incurred were almost $46,000, which was a significant increase from $39,000 odd in the previous financial year. Medium-sized businesses were in the same boat, incurring average losses of around $97,000, which is an increase of around $88,000 in the previous financial year. Cybercrime reports nationwide reveal that New South Wales is the third highest jurisdiction, reporting 21% of Australia's total cybercrimes. In a recent business survey undertaken throughout 2019, with the results being released last year, the Australian Cybersecurity Centre, in partnership with the Behavioural Economics team of the Australian Government survey, revealed some alarming results from 1,700 businesses surveyed. 1 in 5 small, medium businesses were unaware of what the term phishing meant, and we'll talk about that later in the presentation. Almost half of the small, medium businesses reported they spent less than $500 on cybersecurity per year. So that's a very small amount. Small to medium businesses know that cybersecurity is important. However, there are certain barriers and limitations in implementing good practices, those being a lack of resources, a lack of dedicated staff with an IT security focus, a lack of adequate planning and response to cyber incidents. In addition, the Australian Security and Investments Commission, which you'll know as ASIC, which is our corporate regulator, released an annual report last year showing its Cyber Pulse survey to better understand the cyber maturity of regulated organisations. So you may ask, what is cyber maturity? The term means how ready is an organisation to defend itself and its digital assets against cyber attack? This voluntary survey was completed by almost 700 organisations of different sizes and from different sectors. The survey was designed to assess the cyber resilience of participants against a number of key functions being core governance and risk management, identifying and protecting information assets, and detecting and responding to and recovering from cyber events. The survey found small organisations, which in the survey they classed as being of 1 to 25 employees, lagged behind in supply chain risk management, data security, and consequence management when compared to medium to large organisations. Specifically, the responses to the survey indicated 44% of those organisations do not perform risk assessments of third parties and vendors. 33% have no or limited capability in using multi-factor authentication. 45% do not perform vulnerability scans, and 30% do not have backups in place. ASIC recognised, and I quote, small organisations are regularly required to manage competing priorities with limited financial and human resources. It's unsurprising that they consistently reported a lower level of cyber maturity capable of than medium and large organisations. Hence, ASIC sees that outsourcing is essential for small organisations in managing cyber risk. From the statistics, we know that cyber attacks are considerable business problems for businesses of all sizes, including small to medium businesses. And Gigi will now comment on common forms of cyber attacks.
Thank you, Simone. So what is cyber attacks? According to the Australian Signals Directorate, ASD, a cyber attack is a deliberate act through the cyberspace to manipulate, disrupt, deny, degrade, or destroy computers or network on the information resident in them, with the effect of seriously compromising national security, stability, or economic prosperity. To put it simply, cyber attack is an attempt by cyber criminals or hackers to access a computer network or system, usually for the purpose of altering, stealing, destroying, or exposing information. There are many types of cyber attacks, and I'm sure there will be more as cyber criminals become more and more creative. Let's have a look at them. Phishing. Phishing uses emails, SMS, phone, social media in tricking the victims into giving personal information like password, usernames, credit card numbers, bank account numbers, or to download a malicious file that will install viruses on their computers or phone. This often results in the loss of information, money, or even identity theft. An example would be receiving an email that attaches a fake invoice, asking you to pay, or asking you to click on a link to authorize payment. Or you receive an SMS informing you that your bank account has been hacked and request that you provide to them your passcode so that they can access and check your account for you. Malware or malicious software is any program or code that is created with the intent to do harm to a computer, network, or server, and to gain unauthorized access, usually to steal information or disrupt or disable networks. For example, someone bypassing weak security walls or clicking on a link that installs viruses that replicate across the system, which end up taking over your business. Ransomware, a type of malicious software that makes data or systems unusable until the victim makes a payment or ransom. Apparently, there is an increasing trend of ransomware. In 2018, around 10 medium-sized businesses were impacted by ransomware. In 2023, this increased to over 380 on average per quarter. Using a real-life example, Medibank was attacked by a ransomware group based in Russia known as Rebel, who posted a folder containing data samples that included customer medical records, names, and birth dates. The ransom group demanded a $10 million ransom in exchange of recovery and the data not being leaked elsewhere. Ransomware groups are usually sophisticated player, organized group, and highly structured. Targets are chosen based on their ability to pay a ransom, usually large organizations with sensitive data, but that doesn't mean that it cannot happen to small to medium-sized organizations. Business email compromise. It's a form of email fraud where cybercriminals target organizations who scam them out of money or trick employees into revealing important information, often by impersonating trusted senders. For example, your employee receiving an email impersonating you, the CEO, with an urgent request concerning an overdue invoice, obviously asking them to pay immediately. Or you receive a text message from your accounts department asking for the confirmation of your bank account details for payroll purposes, when in fact, it's not from accounts. Denial of service attack is a malicious targeted attack that floods a network with false requests in order to disrupt business operations. In a denial of service attack, you will be unable to perform routine and necessary tasks, such as accessing emails, websites, online accounts that are operated by a compromised computer or network. Whilst most denial of service attacks do not result in lost data and are typically resolved without paying a ransom, they do cost the organization time, money, and other resources in order to restore critical business operations. Data breaches is when a cybercriminal successfully attacks the system and access information without authorization, and sometimes involve exposing the information to a third party. Data leak can be a form of a data breach, but can also occur due to poor data security and protection of the system, as well as employee negligence. As we have seen, cyber attacks certainly have detrimental impact on a business, as they can cause disruption, loss of important or valuable data, loss of reputation, loss of client, which leads to loss of income. Some also bring with it legal consequences, litigation, class actions. And not only that, some may attract legal obligations on the part of their victim, the business that is under attack. Just then, we said data breach happens when information is accessed, lost, or disclosed without authorization. So if a data breach involves personal information, you may be required to report to relevant government authority and also to notify the affected individuals under what is called the Notifiable Data Breach Scheme. Simone, can you tell us more about that?
Yeah, definitely. I'd like to talk about what's called the Notifiable Data Breach Scheme. What is it? In 2018, the Notifiable Data Breach Scheme was introduced. I'm going to refer to it as the Scheme to Notify. The Scheme to Notify requires organisations or agencies that are covered by the Privacy Act to notify any affected individuals and the Office of Australian Information Commissioner if the data breach involves personal information where there is a risk of serious harm. So there has to be personal information and there has to be a risk of serious harm. At the outset, I need to point out the seriousness of a failure to comply with the Scheme to Notify. If you fail to comply, it will constitute a breach of the Privacy Act and can lead to penalties for any breaches. Now, the maximum penalty was recently increased for companies from $2.2 million to up to $50 million. So it's not an insubstantial penalty and shows the seriousness of any such breaches. For individuals, the penalty increased from $444,000 to a maximum of $2.5 million. So the government's getting serious in relation to these types of breaches. So when do you need to report and notify? You need to notify, so that's different to reporting to the Commissioner. Notifying is to the individuals. You need to do that when the data breach is an eligible data breach. So what is an eligible data breach? An eligible data breach is if all of these three criteria are satisfied. Firstly, there has to be an unauthorised access to or unauthorised disclosure of personal information or a loss of personal information that an entity holds. Secondly, that this unauthorised access or disclosure is likely to result in serious harm to one or more individuals to whom the information relates. And lastly, the entity has not been able to prevent the likely risk of serious harm with remedial action. Now, examples of an eligible data breach involving personal information include a device with a customer's personal information being lost or stolen, a database with personal information being hacked, or where personal information is mistakenly given to the wrong person. So we now have to ask, what is personal information? And that's covered in the Privacy Act in Section 4. It is information or an opinion about an identified individual or an individual who is reasonably identifiable, whether the information or opinion is true or not, so the information doesn't have to be true, and whether the information or opinion is recorded in a material form or not. So you don't have to name the individual, they don't have to be named, but they just have to be reasonably identifiable. That's the test. So when I explained one of the requirements relates to serious harm, that definition is not defined in the Privacy Act. So in the context of a data breach, serious harm to an individual may include serious physical, psychological, emotional, financial, or reputational harm. And examples like these are such as identity theft, significant financial loss by the individual, threats to an individual's physical safety, loss of business or employment opportunities, humiliation, damage to reputation or relationships, and workplace or social bullying. So they are all examples of serious harm. When a data breach occurs, the Office of Australian Information Commissioner, which I'll now refer to just as Commissioner, expects an organisation or agency to try to reduce the chance that an individual experiences harm. If they are successful in that quest, the data breach is not likely to result in serious harm. The organisation or agency therefore does not need to tell the individual about the data breach. But conversely, if they are unsuccessful in preventing the likely risk of serious harm with remedial action, the agency must report and notify. Now, not all agencies and organisations need to report and notify. Only agencies and organisations covered by the Privacy Act must comply with the scheme to notify. That is, the scheme to notify only applies to entities that already have an obligation under the Privacy Act to protect the personal information they hold. Now, the entities that are required to comply with the scheme to notify are known as APP entities, and let me explain why. The Privacy Act sets out 13 set Australian privacy principles, which are called APPs, and they regulate how personal information held by entities must be handled. Breaching an APP, so one of those principles, is an interference with the privacy of an individual and can lead to regulatory action and penalties, as I previously discussed. The APP principles apply to APP entities, so they're the entities that are covered under the Privacy Act. They include an individual, a body corporate, partnership, other unincorporated associations or trusts. They also include a government agency. As at today, they do not include a small business, but I'll go on later to explain why that might not be the case in the future. Technically, a small business is not an APP. A small business operator is an organisation that has an annual turnover of $3 million or less for a financial year. And for the purposes of this, annual turnover it includes all income from all sources, but it does not include assets held, capital gains, or proceeds of capital sales. However, like any of these types of definitions, there are exceptions to the small business exemption, which means that notwithstanding your annual turnover may be less than $3 million, your business can still be an APP entity and you may still be covered by the Privacy Act and scheme to notify. Some of the exceptions include when tax file number information is involved or when the business is of a particular nature. These part of the exceptions are things that you should seek some legal advice in relation to, because it gets quite technical in relation to what is actually covered. The takeaway is if you hold TFN information, your business may be an APP entity to which the scheme applies. Now, the Privacy Act also specifically applies to other businesses like health service providers such as GPs, hospitals, aged care, allied health providers, which include audiology, optometry, physiotherapy, OT, complementary, which includes acupuncture, aromatherapy, Chinese medicine, chiropractic and massage. The Act can also apply to gyms or weight loss centres if they collect health information. Entities that are involved in trading in personal information are also covered, and which includes business operators that disclose, say, personal information about individuals to anyone else in exchange for a benefit, service or advantage, or if they provide a benefit, service or advantage through the collection of personal information about another individual or from anybody else. Some examples of breaches: buying a mailing list without first getting the consent of all the individuals on that list, disclosing customer details to someone else for some commercial gain. So even if the Privacy Act and Scheme to Notify do not apply to your organisation today, there are some reforms that are coming, and I think the latest reforms of the privacy law could one day make your company an APP entity. What I think is important to note here is that due to the ever-changing technological developments, community expectations, and the higher rate at which data breaches are affecting small businesses, the government has agreed in principle to remove the small business exemption. It hasn't happened yet, but it probably will happen, which means that small businesses will also be subject to the Privacy Act and the Scheme to Notify. It's a bit of a watch this space at present. Now, the Commissioner's website provides a privacy checklist for small businesses to determine whether an organisation has obligations under the Privacy Act. However, it is always best to seek legal advice to ensure that you correctly identify whether your organisation is subject to the Privacy Act and Scheme to Notify, or whether you fall within one of the exemptions. So, what do you do in the event of a data breach? If your organisation is an APP entity, in the event of a data breach, the Privacy Act requires your organisation to take reasonable steps to assess the data breach within 30 days of becoming aware of grounds to suspect that your organisation may have experienced an eligible data breach. Once your organisation forms a reasonable belief that there has been an eligible data breach and you have not been able to remedy it, you must notify affected individuals and the Commissioner as soon as practicable. To notify the Commissioner, you're required to prepare a statement, which is called a notifiable data breach form, which I'll refer to as a statement. The statement must include the name and contact details of your entity, a description of the eligible data breach, the kind or kinds of information involved, and what steps the entity recommends that individuals at risk of serious harm take in response to the eligible data breach. The Commissioner's website has a step-by-step guide that you can follow when submitting the statement. Affected individuals can be notified in one of three ways. You can notify all individuals. You can notify only those individuals at risk of serious harm from the eligible data breach. However, of course, you must first identify who are at risk of serious harm and why. If neither of those are practicable, you may publish a public notification. This must be done by publishing a copy of the statement lodged with the Commissioner on its website if the organisation has one, and take reasonable steps to publicise the contents of the statement. Each of the ways of notification have their own impact on an organisation. So in the unfortunate event of a data breach, and when a company is under tremendous stress, not only does it need to identify the breach, assess the extent of the breach, assess the information involved, take immediate steps to contain or minimise the breach to affected individuals, there are certain legal obligations that must not be overlooked. The process can be confusing and stressful at the same time. We suggest that you consult with your IT expert early in the assessment stage to ensure that from an IT perspective, you are dealing with the breaches in the most effective way. Now, at the same time, we also recommend that you consult with your lawyers. It is easy to think that cyber, computer, cloud-based issues are only IT-based. However, when it comes to cyber breaches, lawyers play a very important role in the process. Lawyers can assist with the drafting of the statement to the Commissioner and any public notice to affected individuals. They can also work with your public relations team, as we understand there may be certain implications associated with the public notification. Some of them will have a highly detrimental impact on your organisation. From experience, most businesses would prefer not having a publicly notifiable data breach and possibly not notify at all if it can be avoided. Lawyers can help assess risks and protect your company from making decisions that might create future harm to your business. ASIC once reported that organisations that mishandle reporting cyber breaches will face significant consequences due to the unmet complex requirements of the privacy law. In the recent data breach report statistics released by the Commissioner last month, the Commissioner said that the scheme to notify is now well established and the Commissioner expects organisations to comply with their obligations. So they're cracking down, they're getting tough, and they're not going to accept any excuses anymore. The Commissioner is escalating its regulatory activities into data breaches and have commenced civil penalty proceedings in the federal court. Having a data breach is bad enough for any organisation. However, imagine your company also having to face penalties. Lawyers can advise you of your legal obligations and the steps in complying with those obligations to assist. Now, they can also assist with other communications to affected individuals and the Commissioner during the process. For example, sometimes you need to do an interim assessment outcome notice or provide updates. They can assist you with the drafting of these crisis communications to ensure that they contain appropriate information so as to not expose the organisation to any unnecessary additional risk. They can also advise organisations on steps to take to remediate or reduce the risk of further damage. For example, obtaining interim urgent injunctions to stop any perpetrators who may have access to the authorised information from disclosing or using same. Depending on the type of cyber attack, decisions like, do we pay the ransom? If we do, are we at risk of breaching any other law? If we comply with the attackers, what happens? You could be in breach of any of the anti-terrorism laws or anti-money laundering laws, so you've got to be very careful in making those decisions. In addition, it is open for affected individuals to take out class actions, such as the current class action against Optus. In the latest privacy law reform, the government agrees that individuals currently have very limited avenues to seek redress for interferences with their privacy. Therefore, the government has agreed in principle that individuals should have more access to the courts to seek remedies. As such, the Board and Executive Committee of organisations who have certain legal obligations to protect the organisation are best to be legally informed in preparation for cyber attacks. In addition, legal professional privilege on important documents is another issue that must not be overlooked. Legal professional privilege allows a person or an organisation to resist demands to disclose information or produce documents which would reveal communications between a client and their lawyer, where those communications were made for the dominant purpose of giving or obtaining legal advice or services. Legal professional privilege also covers documents like reports prepared by experts for use in current or anticipated litigation. It is not unusual for IT reports on the preliminary assessment of a data breach to contain information that you may not want to disclose. They may occur in circumstances where you actually get a report and it says that your systems were not correct or you should have done something previously and you failed to do that. They'll end up in a report somewhere. It's best for lawyers to retain the IT experts on your company's behalf to ensure that all instructions, reports, and documents are generated from the moment a cyber incident is detected. Otherwise, what can happen is what happened to Optus in the federal court. Optus's application for privilege over Deloitte's investigation report, which was a report that Optus actually had Deloitte undertake for them, was handed over to the court. They resisted it. Optus did not want the investigation report disclosed, as they had retained Deloitte to undertake that report, and there were some things in there they did not want the court to see. However, the report was not commissioned under legal professional privilege and was therefore open to be produced to the court. The last thing that any organisation wants is to have a report commissioned by it in a crisis to be used against itself in legal proceedings. So it is extremely important in these types of circumstances to try and ensure the legal professional privilege is maintained over any documentation whatsoever that may end up in legal proceedings later on. So Gigi, I'll let you talk about cybersecurity.
Okay. Now that we know cyber attacks can be a big problem for our businesses and the detrimental follow-on effect, as well as the very complex legal requirements associated with it, we urge you to take action. It's time to check on your organization's cybersecurity and improve it if necessary. So what is cybersecurity? It is the practice of protecting systems, networks, and programs from digital attacks. Prevention is better than a cure. For this reason, having proactive and effective preventive measures is important. This will not only reduce the likelihood of your system being attacked, but will also minimize the stress and mitigate any adverse impact in the event of a cyber attack. We have 5 actions that we can suggest, and we think they shouldn't break the bank. Action 1, first and foremost, because it is your company's data that you're trying to protect, you need to know your data. You need to know the data that you're holding. Why did you collect them in the first place? You need to know who has access to those data, especially if it involves sensitive information. Is there a system in place where access to those data is only limited to the staff that requires them to do their job? Or are they readily accessible by anyone, everyone? No control increases the chance of data being leaked. Do you still need the data? There are certain statutory obligations in relation to the storage of records. For example, 7 years for business and financial records, 5 years for tax records, and 7 years for employees' records. You also need to know your obligation to destroy data. A lot of organizations overlooked on the need to destroy data. As time goes, a company with a turnover of staff may lose track of the information that it holds, which can make identifying the information that may be subject to a data breach very difficult. Importantly, there are also obligations on the APP entities to destroy data. APP entities must destroy or de-identify records containing personal information if the entity no longer needs it for the purpose for which it was collected. APP entities must also take reasonable steps to securely destroy or permanently de-identify text file number information that is no longer required by law to be retained or no longer necessary. The Commissioner is prioritizing regulatory actions where organizations are holding onto data much longer than it is necessary. Action number 2. You need to know who is protecting your data and how well is it protected. You need to know where your data is stored. Is it internal or external by service providers? Is it secure? Are there any risks involved? The Commissioner's data breach statistics have recently highlighted the risk of outsourcing personal information handling to third parties. The Commissioner has been notified that a high number of multi-party breaches, with most resulting from a breach of a cloud or software provider. Multi-party breaches involve multiple parties holding the same information that is subject to a leak. For example, your organization and a cloud provider. Therefore, organizations need to proactively address any privacy risks in contractual agreements they have with third-party service providers. We recommend you seek legal advice when reviewing these contracts. You should also check that all your software is up to date, including antivirus software. Is someone monitoring my system continuously for any suspicious activities? Do we do regular backup of our data? To properly understand the strength of your system against cyber attack, we suggest you get external IT professionals to test the system, try penetrating it, assess its strength, implement changes if required, and continue monitoring it This is over and above your normal IT support. If you do not currently have contacts of these IT experts, please feel free to contact us, as we have some connections that we can refer. Action number 3, educate your staff. Statistics have reviewed that approximately 95% of all data breaches are caused by employee negligence. Educating staff on secure and effective technology use will reduce harm significantly. So how can this be achieved? You can do that by implementing stronger verification mechanisms, for example, mandating stronger passwords or passphrases, turn on multi-factor authentication, holding regular workshops to remind your staff on the proper use of devices, the internet, and how to identify harmful software or emails. Conducting ad hoc testing to check on how responsive your staff is to potential risks. You can try sending fake emails and see if they can pick it up. Having a policy on the use of devices like laptops and phones, especially when connecting remotely. Action number 4, have a cybersecurity policy and a data breach response plan in place. A cybersecurity policy is a document that provides guidance to staff member on what to do to protect the company's sensitive information. The policy outlines the technology and information assets that the business needs to protect and the possible threats to those assets. It also sets out the rules and controls that a staff member needs to follow to protect the information and the business. This policy could also include some of the matters that we just mentioned, like password, having passphrases, having policy on devices. This will be an important document for staff training purposes on cybersecurity and risks. As we all know, cyber attacks come without warning, and there are many matters that an organization will need to address within a very short period of time. Apart from identifying the stolen information and deciding whether there is need to report or notify, the company will also need to work out whether or not it can continue operating in those circumstances. What are the actions that they need to take internally? Who do we inform? When people are in the panic mode, it is best to have a plan. A data breach response plan can help you meet your obligation under the Privacy Act. Under the Privacy Act, an entity must take reasonable steps to protect the personal information that it holds. Having a data breach response plan can be one of these reasonable steps. The plan can also limit the consequences of a data breach. A quick response can reduce the likelihood of affected individuals suffering harm. It can also lessen financial and reputational damage to the organization that experienced the breach. The plan can also preserve and build public trust. An effective data breach response plan can build customer and public confidence on your organization's respect for individual privacy. It also demonstrates that your organization has taken steps to protect their personal information. So a data breach response plan sets out the roles and responsibility of staff involved with managing a data breach. It also describes the steps to take when a data breach does occur, so the staff will know exactly what to do and who to report to. The last thing you want is to have a cyber attack and then a staff member doing the wrong thing and making it worse. That can lead to serious legal consequences or further money loss. Once you have the plan, you need to regularly review and test it to make sure that it is up to date and that your staff know what is expected of them. You can test your plan by doing a cyber breach drill. Lastly, number 5, consider and know where to get cyber insurance. Cyber insurance, like any other kind of insurance, should be part of an organization's risk management strategy. How an organization can respond to and recover from a cyber incident or data breach can be materially impacted by whether they have cyber insurance. The key thing to remember about cyber insurance is that it should be specifically designed to address cyber risk. It is best to be a standalone cyber policy and not an extension of other insurance policy. Cyber insurance is designed to cover the organization through the entire life of the cyber event, from initial discovery of the data breach and responding to it, through a recovery process, and for any third-party claim or regulatory investigation. There are two main forms of cover. First-party cover. It's all about the incident itself. This insurance covers the first party, that is you, the client, and the organization that is being attacked. The cover generally includes incident response costs. They are the costs incurred to engage legal, IT forensic, crisis management, public relations, and other experts that you may need to respond to the incident. It also covers business interruption loss, but there is usually subject to some limit, like a number of hours or within a certain period of time. It also covers data asset recovery costs. So that's when data is lost and needed to be recovered. Extortion costs, reimbursement of any ransom paid, but subject to certain restrictions like anti-money laundering laws, and also the costs involved in negotiating. The second form of cyber insurance cover is third-party cover. This is all about the data breach incident coming back to bite you. The cover generally includes liability claims from third party because of the incident, or regulatory fines and penalty arising from an investigation. So these are just common types of cover. Every cyber insurance policy is different. You should carefully read the product disclosure statement to understand what it covers and what is excluded. So as we come to the end of the webinar, we thought it would be good to include some special reminders for the upcoming Easter break. It is not uncommon that cyber criminals strike during holiday seasons when most organizations may be understaffed or less vigilant. We ask that you consider sending reminders to staff or even your clients before the holiday. To warn your clients to always phone your organization to confirm the bank account details before paying funds electronically, and direct them to call the number on your website, your email, and the usual number. Always verify bank account details that you receive in an email with your payee before processing a payment. Once you have authorized payment to non-verified payee, like a cyber criminal, there is a high chance that you will not be able to recover it. Credit card companies do not reverse transactions that have been authorized by you, even though it was fraudulent. When making payment, always double check the bank details. Many banks now have name matching technology, which provides an alert if the account name doesn't match the bank details. Do not ignore bank alerts, as it can be the first indication that fraud is being attempted. Be wary of social and unexpected communications like emails, SMS, phone calls, especially when those requesting for account information, password, telling you that their bank account details have changed and you need to pay to someone else, asking you to log into verified details, or the ones with a lot of typos or grammatical errors, or simply look suspicious. Always inspect the links and attachments before clicking and opening. Make sure the destination domain name matches the real business. If in doubt, don't click and delete it. Check with your IT and cybersecurity provider for their operating and coverage hours over the holidays. Make sure you have adequate support in the event of a cyber attack. Cyber has become a necessity for all businesses, regardless of its size, to keep functioning in this modern technological world. Ignorance of the current risks associated with cyber threats and attacks can cause serious consequences for your organization, your staff, and clients. For these reasons, being cyber resilient and keeping up to date with cyber law should be of paramount importance. This will ensure that in the unfortunate event of a cyber attack, you and your staff know exactly what to do and that your business will be back up and running as quickly as possible. Thank you so much for watching, and we hope that you find